My name is Claire Merritt, and I was 43 years old when my husband stood in our kitchen in the house we had bought together, in the town where I had buried 2 dogs, planted a garden, and raised a son, and told me he had already given it all away. But I'm getting ahead of myself. Let me go back to when it was still good, or at least when I still believed it was. Daniel and I met in our mid-20s at a company picnic of all places. He was charming in that easy, unhurried way that some men carry effortlessly. He laughed at his own jokes before he finished them. He remembered how I took my coffee after one conversation. I fell in love the way you do when you're young and haven't yet learned to ask the right questions. We married 3 years later, bought our house in Naperville, Illinois at 30, and had our son, Marcus, at 32. From the outside, we looked like exactly what we were supposed to be. The house was a 4-bedroom colonial on Elmwood Drive. I had chosen the paint colors for every room. I had refinished the floors with my own hands one summer, while Daniel was traveling for work. I had planted lavender along the front walk because I read somewhere that it keeps mosquitoes away. I love that house the way you love something you have genuinely earned. For the first decade, I had no reason to doubt what I had. Daniel worked in commercial real estate development. I was a paralegal at a mid-size firm in the city. We shared finances, shared dinners most nights, shared the ordinary rhythms of a functioning life. Were we passionate? Not anymore. But I had stopped expecting passion. I expected partnership. I thought that was what we had. The first warning sign came so gently I almost missed it. It was a Tuesday in February. I remember because I had just come home from a deposition that had run 3 hours over schedule, and I was exhausted down to my teeth. I walked into the kitchen and found Daniel on the phone, speaking quietly, turned toward the window. The moment he heard me, he said, "I'll call you back," and hung up. He turned and smiled at me like nothing had happened. I told myself it was work. He was always on the phone for work. But I noticed. The way you notice a single thread loose on a sweater and choose for a while not to pull it. The calls became a pattern over the following months. Always quiet, always ended when I entered the room. He began going to his mother's house in Oak Park more frequently. Patricia Merritt, a woman who had never particularly liked me and had never bothered to pretend otherwise. Patricia was 71, sharp-tongued, and had always treated our marriage as a temporary arrangement she was willing to tolerate. Daniel adored her in the way some sons adore difficult mothers, completely, blindly, without question. I started to notice that he and Patricia were spending time together without explanation, Sunday afternoons, occasional weekday evenings. Once I drove past her house on my way home from the grocery store. I wasn't following him. I want to be clear about that. It was simply on the route. And I saw his car in her driveway at 9 o'clock on a Wednesday night. Was I paranoid? I asked myself that constantly. I was a paralegal. I read contracts for a living. I knew how to look for what wasn't said, for the space between the words. And the space between Daniel's words had been growing for a year. Then came the morning everything changed. It was a Saturday in late October. Marcus was away at college, Ohio State, his second year. Daniel and I were alone in the house, which was not unusual, but the silence that morning felt different. Weighted. He came downstairs in jeans and a flannel shirt, poured himself coffee, and sat across from me at the kitchen table. He didn't look nervous. That was what I remember most. He looked almost relieved. "I want a divorce," he said. I set down my mug. I looked at him. I waited. "I've already spoken to an attorney," he continued, "and I want you to know, I had the house transferred into my mother's name 6 weeks ago. Legally, it's hers. You don't have a claim on it. When this is done, Claire, you'll walk away with nothing." He said it calmly, clinically, like he was reading from a document he had rehearsed, and I laughed. Not because it was funny, not because I wasn't afraid. I laughed because I had known this moment might come. Not this exact moment, not these exact words, but something like this. And 10 years ago, quietly, without telling a single person, I had done something about it. Daniel stared at me. The relief on his face curdled into something uncertain. "What's funny?" he asked. "Nothing," I said, and picked up my coffee again. "Go ahead and call your attorney." I went upstairs after that. Not dramatically. I didn't slam doors or cry in the hallway. I simply excused myself, walked to our bedroom, closed the door behind me, and sat on the edge of the bed for a long time. The fear came then, when I was alone. It was physical. A tightening in my chest, a cold feeling in my hands. I had been a paralegal for 15 years. I understood better than most wives in my position exactly what it meant when a husband transferred a marital asset into a third party's name before filing for divorce. I understood the legal architecture of what Daniel had attempted to construct, and I understood how devastating it could be to someone who didn't know what I knew. I allowed myself 20 minutes of fear. Then I opened my laptop. Let me tell you what I was working with. Our house on Elmwood Drive had been purchased in both our names in 2007 for $340,000. By that October, it was worth somewhere between $580,000 and $610,000, based on recent comps in the neighborhood. I knew this because I had looked it up 6 months earlier when I started feeling that something was shifting in our marriage. That house represented the single largest asset we shared. Daniel's income had always outpaced mine. His pension, his 401k, his investment accounts, those were significant. But the house was what I had helped build, physically and financially. I had contributed to every mortgage payment. I had done work on that property with my own hands, and he thought he had taken it from me by signing a piece of paper. I thought about Marcus. He was 20 years old, studying engineering, largely unaware of the state of his parents' marriage. What would this do to him? What would it mean for him to watch his mother be legally stripped of her home by his father and grandmother? I couldn't think about Marcus for too long without the fear becoming something else, something harder and colder that I didn't have a name for yet. I thought about Patricia. I had never trusted that woman. She was the kind of person who smiled while calculating, who offered compliments shaped like criticism. She'd always wanted Daniel closer, more dependent, more hers. Had she encouraged this? Had she been part of the planning? The thought settled into me like a stone dropped into still water. I had 2 choices. I could panic, hire the first divorce attorney I could find, fight reactively, let Daniel and Patricia set the terms of this battle while I scrambled to catch up. Or I could be what 15 years of reading legal documents had trained me to be, careful, methodical, and several steps ahead. I chose the second option. That afternoon, while Daniel was presumably on the phone with his attorney or his mother, I could hear him downstairs speaking in that same low, careful voice. I drove to a coffee shop on 5th Avenue, ordered a black coffee I barely touched, and opened a legal pad. What did I know? I knew that in Illinois, a transfer of marital property made in anticipation of divorce can be challenged as a fraudulent conveyance. I knew that the timing, 6 weeks before filing, was highly suspicious and potentially reversible by a court. I knew that I had documentary evidence of my contributions to the house, bank statements, joint mortgage records, home improvement receipts, contractor invoices with my name on them. I knew that I had worked as a paralegal long enough to understand how to compile that documentation in a way that would be useful to an attorney. And I knew something else. Something I hadn't told Daniel about. Something I had done 10 years ago, quietly, without fanfare, without explanation, because a small, careful part of me had always understood that in this life, you protect yourself. 10 years ago, I had consulted a real estate attorney, a woman named Barbara Kowalski, who had an office in Evanston and specialized in marital property law. I had gone to her not because I was planning to leave my marriage, but because I had been reading a case at work involving a woman in circumstances uncomfortably similar to mine, and something in me had whispered, "Document everything." Barbara had advised me to do something very specific, and I had done it. And then I had filed the resulting paperwork in a fireproof lockbox in the back of my closet behind a stack of winter sweaters, where it had stayed for 10 years, waiting. I was not ready to reveal that yet. Not to Daniel, not to anyone. A plan only works when the other side doesn't know you have one. My first steps were practical. That evening, after Daniel had gone to bed, in the guest room I noticed, which told me the performance of our marriage was already over for him, I spent 3 hours making copies of every joint financial document in our home, mortgage statements, tax returns from the last 7 years, joint bank account records, the deed to the house, which I photographed front and back, the records of every home improvement project we had undertaken, including the summer I refinished the floors, for which I still had the receipts from the lumber yard. I organized everything into a manila envelope, sealed it, and drove it to my office the next morning before Daniel woke up. I stored it in my desk drawer under a stack of ordinary files. Then I called Barbara Kowalski. She picked up on the third ring, and I said, "Barbara, this is Claire Merritt. You helped me with something about 10 years ago. I think it's time to talk about it." There was a brief pause, and then she said, "I remember you, Claire. Come in this week." I hung up, sat in my car in the parking garage for a moment, and felt something I hadn't expected. Steadiness. Not happiness. Not confidence exactly. Just the quiet, grounded feeling of a person who has stopped reacting and started moving. Daniel didn't know what was coming, and Patricia certainly didn't. That thought in that gray November morning in a concrete parking garage was the first thing that had made me feel like myself in weeks. Barbara Kowalski's office was exactly as I remembered it. A narrow suite on the 3rd floor of a building on Davis Street in Evanston, with tall windows that let in pale winter light and walls lined with a kind of organized bookshelves that communicate competence without effort. She was in her late 50s now, silver-haired, with reading glasses pushed up on her forehead. She shook my hand firmly and gestured to the chair across from her desk. "Tell me what happened," she said. I told her. I was precise. I laid out the timeline, the change in Daniel's behavior, the frequent visits to Patricia's house, the transfer of the deed, which I had since confirmed by pulling the public property records myself, a habit of professional reflex, and the conversation at the kitchen table. I did not editorialize. I spoke the way I had learned to speak preparing attorneys for depositions. Facts, sequence, documentation. Barbara listened without interrupting. When I finished, she folded her hands on her desk and looked at me steadily. "The transfer," she said, "was made 6 weeks before he filed. In Illinois, that's within the window we'd want to examine for fraudulent conveyance. If we can demonstrate that the transfer was made with intent to deprive you of a marital asset, A court can void it." "I know," I said. She smiled slightly. "Of course you do. Now, you mentioned something on the phone, something from 10 years ago." I reached into my bag and placed the envelope on her desk. Inside was a single notarized document, a transmutation agreement, a legal instrument in which both spouses formally acknowledged the character of a property as marital. Daniel had signed it. I had witnessed it notarized. It had been executed in this very office 10 years ago, when I had convinced Daniel, gently as part of a conversation about estate planning, framed as something routine, to sign several documents related to our shared assets. He had been distracted that day, I remembered. He'd had a work call. He'd signed where I pointed and gone back to his phone. The transmutation agreement explicitly stated that the Elmwood Drive property was marital property, regardless of how title was held or subsequently transferred. Barbara picked up the document. She read it. She set it down. She looked at me over her reading glasses. "Claire," she said quietly, "this changes everything." "Yes," I said, "I thought it might." What that document did, in practical terms, was this. It created a binding legal record, executed by Daniel himself, acknowledging the marital character of the house. Any subsequent transfer, including the one to Patricia, could be challenged not merely on fraudulent conveyance grounds, but as a violation of an existing agreement. It made Daniel's position substantially weaker. It made Patricia's ownership claim precarious, and it was executed before any marital conflict had arisen, which meant it could not be characterized as a defensive maneuver. It was simply a document that existed. Barbara agreed to represent me. We spent 2 hours that afternoon mapping out our strategy. She would file a formal response to the divorce petition, including a motion to void the property transfer. She would request full financial disclosure from Daniel, his accounts, his income, his pension, through the standard discovery process. And she would, at the appropriate moment, introduce the transmutation agreement. "He doesn't know about this document?" Barbara asked. "He signed it in a distracted rush and forgot about it within 20 minutes, I said. "To my knowledge, he has never thought about it since." "Good," she said. "Let's keep it that way for now." I drove home that evening feeling the particular calm of a person who has placed their most important card face down on the table. The game was not over. It hadn't truly begun. But I knew something Daniel didn't. And in any conflict, that asymmetry is everything. What I didn't know, driving home on the Eisenhower Expressway with the Chicago skyline behind me, was that Daniel had already begun to notice something was wrong. He called me that evening while I was making dinner. I was in the kitchen, our kitchen, standing at the stove we had argued over purchasing, because it was more than we needed. He was in the living room, and he came to the doorway. "Did you speak to someone?" he asked. "About what?" "An attorney." I turned and looked at him. "Why would you ask me that?" He watched me for a moment. "You seem different." "I'm the same," I said, and turned back to the stove. But he wasn't wrong. I was different. The woman who had sat on the edge of the bed 24 hours ago with cold hands and a constricting chest was gone. What had replaced her was harder and more patient. 2 days later, I received a call from a colleague at my firm, a woman named Jan, who handled real estate closings and had a habit of noticing things. She told me carefully that a man she believed was Daniel had called the firm's main line asking if I had recently consulted any attorneys within the building. The message was clear. Daniel was checking. He was beginning to feel the shape of something he couldn't quite see. And Patricia, I learned this later through a mutual acquaintance who had no idea she was giving me useful information, had told someone at her church that she was certain the house was settled and secure, and that Claire won't be a problem. I wrote that down in my legal pad when I heard it. Underneath it, I wrote, "Point of no return." They had made their move. They had counted their victory. They were already relaxing. That was their first real mistake. Barbara filed the motion on a Thursday morning. By Friday afternoon, Daniel's attorney had received it. I know this because Daniel called me at 4:47 p.m. I still have the call log. And his voice, for the first time in this entire ordeal, had lost its practiced composure. "What is this document?" he said. "You'll need to speak with my attorney," I said. "Claire." "Daniel, I'm not going to discuss this with you directly. That's what attorneys are for." I hung up. The motion Barbara had filed was precise and comprehensive. It challenged the property transfer to Patricia on 2 grounds: fraudulent conveyance under Illinois statute and violation of the transmutation agreement Daniel had executed 10 years prior. Attached were certified copies of the deed history, our joint mortgage records, my documented financial contributions, and the notarized agreement itself. It was, in Barbara's words, a clean filing, meaning it would not be easy to dismiss. What happened next confirmed everything I had suspected about the nature of the opposition I was facing. Patricia called me directly on Saturday morning. I had not spoken to my mother-in-law in 6 weeks, since before Daniel filed. Her voice was controlled, but the edges of it were sharp in a way that reminded me of a knife being handled carefully by someone trying not to appear dangerous. "Claire," she said, "I think we need to have a conversation, just the 2 of us." "Patricia," I said, "you are a party in my divorce litigation. I'm not going to have a private conversation with you." A pause. "I think you're making a serious mistake. I think I'll let the court decide that. Daniel and I have resources you don't have." A beat. "And connections you don't have. I want you to understand that." I wrote down the time and exact words of the call immediately after hanging up. I forwarded my notes to Barbara. Barbara noted that if the statement about connections could be interpreted as a threat related to ongoing litigation, it might become relevant later. Daniel appeared at the house that weekend. He had moved to Patricia's in Oak Park after our kitchen conversation, taking a bag of clothes and his laptop. He let himself in with his key on Sunday afternoon while I was in the garden. He walked out to the back and stood watching me for a moment. "You need to drop this," he said. "The document is a decade old. My attorney says it won't hold." I pulled a weed from the base of the lavender and didn't look up. "Your attorney is welcome to make that argument. My mother is going to fight this, Claire. She has the money to fight it longer than you do." I stood and brushed dirt from my hands. I looked at him. This man I had been married to for 17 years, standing in the garden I had planted, and I felt something I hadn't expected. Not anger, not grief, but a kind of distant clarity. "You should go," I said. He stared at me. I could see him trying to locate the version of me he had expected to find. Frightened, reactive, overwhelmed. She wasn't there. He left. The escalation came midweek. Daniel's attorney filed a motion arguing that the transmutation agreement was obtained under economic duress and misrepresentation. A creative but legally thin argument, since Daniel had signed the document voluntarily at a neutral attorney's office with no financial pressure present. Barbara called me to discuss it, and I could hear the professional disdain in her voice. "They're arguing he didn't understand what he signed," she told me, "which will require him to testify that he signed a legal document without reading it. Judges tend not to look favorably on that." What do we do? We respond and we prepare for discovery. The week had been exhausting in the specific way that sustained conflict is exhausting. Not one dramatic blow, but a constant low-grade expenditure of attention and energy. By Friday, I had eaten poorly, slept badly, and answered more emails than I could count. Barbara, to her credit, noticed. "Claire," she said at the end of our Friday call, "take the weekend. Don't look at any of this. Let me do my job." I drove north on Saturday. I had a college friend named Renata who lived in Madison, Wisconsin. We had known each other since our 20s, the kind of friend who requires no explanation and offers no judgment. I called her from the car and she said simply, "Come, I'll make soup. 2 days in Madison." Renata's house was small and warm and smelled of coffee and old books. We didn't talk about Daniel for most of the first day. We watched bad television and took a long walk along the lake and ate the soup she had made, which was lentil and deeply comforting. On the second day, I told her everything. She listened. She didn't try to fix it or reframe it or tell me what she would have done. She just listened, and when I finished, she said, "You're going to be all right, you know." I drove back to Naperville on Sunday evening. The house on Elmwood Drive was quiet. I walked through the rooms, the refinished floors, the paint colors I had chosen, the lavender still visible through the kitchen window in the last of the autumn light. And I felt, for the first time, that I was fighting for something real. I was ready for whatever came next. The offer came through Daniel's attorney in the form of a formal settlement proposal, delivered to Barbara on a Tuesday morning approximately 2 weeks after the initial filing. Daniel was willing, the proposal stated, to give me a cash payment of $85,000 in exchange for dropping the challenge to the property transfer and accepting a no-contest dissolution of the marriage. He would retain the house, or rather, Patricia would retain it in her name as he had arranged, and I would receive the cash, my personal belongings, and what he characterized as a clean break. Barbara called me and read it to me over the phone. I sat with it for a moment. $85,000 was not nothing. In another version of this story, the version where I hadn't spent the last 10 years keeping careful records, where I hadn't had that quiet, precautionary conversation with a real estate attorney at 33. It might have been the best I could hope for. It might have been the thing I took, because it was something and something was better than nothing. But the house was worth over $500,000. My legal position was strong, and the $85,000 offer told me something important. Daniel and Patricia were worried. People who hold unassailable positions don't offer settlements. People who know they might lose do. "Decline," I told Barbara. "I'll inform them." And Barbara, can you note in our response that we found the offer to be not reflective of the actual value of the marital estate? A pause. I can say something to that effect, yes. Good. The days that followed were quieter than I expected. Daniel and Patricia, having received the rejection, appeared to pull back. There were no calls, no appearances, no further maneuvers. I imagined them regrouping. Patricia at her kitchen table in Oak Park, going over numbers with Daniel, trying to find a different angle. The image didn't frighten me. It almost made me feel composed. Was I cold? People sometimes use that word for women who don't cry publicly in difficult situations. I wasn't cold. I was conserving. There's a difference. I returned to work, which helped. The office was ordinary in a way I needed. The hum of air conditioning, the rhythm of document review, the particular focused attention required by my job. My colleagues, for the most part, didn't know what was happening in my personal life. I had told only one person at work, my supervisor, a woman named Diane, who had herself been through a difficult divorce 8 years earlier and who received the information with the kind of quiet understanding that requires no performance. "Take whatever time you need for appointments," she said. "We'll cover it." I thanked her and went back to my desk. The genuine social support I found came from 2 directions, and both of them mattered more than I would have predicted. The first was Renata, who had shifted from weekend friend to something more consistently present. She called me every 2 or 3 days, not to ask for updates, but simply to check in. "How are you sleeping?" she'd ask. "Are you eating like a person?" Her consistency was a kind of anchor. I knew the call was coming. I knew there was someone tracking the ordinary facts of my well-being. The second was more unexpected. Marcus called me on a Wednesday night, my son at Ohio State, who I had been careful not to burden with the details of what is happening. He said he had spoken to his father, and his father had told him about the divorce. I braced myself. Marcus was 20 years old. He loved both his parents. This was going to be complicated. But what he said was, "Mom, Dad wasn't very honest with me about things. I could hear it. Are you okay? Do you need anything?" I had to be very still for a moment before I could answer. "I'm okay," I told him. "I'm handling it." "I know you are," he said. "I just wanted to say, I know you're not the one who started this." I didn't ask him how he knew. I didn't need to. Marcus had grown up watching 2 people navigate a household. He was perceptive in the way that children of complicated marriages often are. Quietly, precisely, without drama. We talked for an hour, not about the legal proceedings, about his classes, his roommate situation, a project he was working on that he was genuinely excited about. By the end of the call, something in my chest had loosened that I hadn't realized was tight. I went to bed that night earlier than I had in weeks. I slept without waking. The war was ongoing, but I was not fighting it alone. And Daniel and Patricia, watching from whatever vantage point they had chosen, I could almost feel their eyes, their calculation, their weight, were about to discover that patience in the hands of the right person is not passivity. It is preparation. They came on a Saturday afternoon, the 2 of them together, which told me everything about what kind of visit this was going to be. I watched them come up the front walk through the kitchen window. Daniel in a coat I had given him 2 Christmases ago, Patricia in her good wool jacket, the one she wore to church and to events she considered important. They rang the doorbell. I waited a moment. Then I opened the door. "Claire." Daniel's voice was warmer than it had been in weeks. "Can we come in? We just want to talk." I looked at Patricia. She had arranged her face into something resembling concern. "You can come in," I said, "but I want to be clear. I'm not going to make any agreements without my attorney present." "This isn't about agreements," Daniel said. "We just want to have a conversation, like adults." I stepped back and let them in. We sat in the living room, they on the sofa, me in the armchair across from them. The geometry of it felt deliberate. Patricia folded her hands in her lap. Daniel leaned forward with his elbows on his knees, the posture of someone performing candor. "Claire," he said, "I think we've let this get out of hand. I don't want this to be a war. It didn't have to be, I said. You're right. I made mistakes. I handled things badly at the beginning. He paused. I'm willing to do things differently. But this legal challenge, it's going to drag on for months, maybe over a year. Is that really what you want? Fighting in court while Marcus watches? And there it was. The first real card. Marcus. The invocation of our son as a reason for me to stand down. I breathed evenly. Marcus is an adult. He can handle the truth. Patricia spoke for the first time. Her voice was measured, almost gentle, which was, in my experience of her, the most dangerous register she operated in. Claire, I've always respected you. I know we haven't always been close, but I want you to know that I don't bear you any ill will. I only accepted the house into my name because Daniel asked me to, as a practical matter. I'm willing to work with you on something fair. What does fair look like to you, Patricia? I asked. $100,000, she said. Cash, paid within 60 days of the divorce being finalized, and we all move on with our lives. I looked at her. 71 years old, silver hair, capable hands. She had raised Daniel. She had held this family at arm's length for 17 years, while I planted lavender in its front garden and refinished its floors. And now she was sitting in my living room, offering me $100,000 for a property she would sell for 6 times that. I appreciate the offer, I said, but I'm going to continue with my legal process. Daniel's composure cracked slightly. Claire, this is irrational. You're going to spend tens of thousands in legal fees. I've accounted for that. And put Marcus through. Don't use our son as a negotiating tool, I said. My voice was calm. I'm asking you not to do that. Daniel stood up. The performance of reasonableness was over. You're going to lose, he said. My mother owns that house, legally. Whatever document you have from 10 years ago, my attorney is going to challenge it, and it's going to drag through the courts. And you are going to spend every dollar you have on attorneys before it's done. Then we'll find out, I said. Patricia rose too. She had not raised her voice once. That somehow was worse. I had hoped we could avoid this, she said. I want you to understand that we will not settle again. The next offer was the last offer. I understand, I said. I walked them to the door. I watched them go down the front walk, Daniel tight-shouldered, Patricia still composed, and I closed the door and stood in the hallway. The fear came then. It was real, and I won't pretend it wasn't. Patricia's composure was the fear, the sense that she had calculated something I hadn't, that there was a move I didn't see. She was not a stupid woman. She had resources. She had connections she had mentioned once, and not again. But the fear was information. It told me to be more careful, not less, to check every assumption, to not allow myself the luxury of assuming I had already won simply because I had a strong position. I called Barbara that evening and told her about the visit. She listened, asked several precise questions, and said, "They're rattled, Claire. Rattled people make mistakes." "I know," I said, "but you should also know. They may try harder in the next phase. Discovery is coming. They're not going to enjoy it." I hung up and went to the kitchen and made myself tea and stood at the window and looked at the lavender, frost-bitten now in November but still structural, still there. Fear was one thing, but underneath it, underneath the cold recognition that I was in a real fight with real opponents, there was something else. something that had been building since that morning at the kitchen table when Daniel told me I would have nothing, and I had laughed. I was going to see this through, whatever it cost, however long it took. They had underestimated me for 17 years. I had let them. Never again. The hearing was scheduled for a Thursday in February, 4 months after Daniel had filed. Barbara had prepared me thoroughly. We had met 6 times in the preceding weeks, sometimes in her office, sometimes by phone, going over the likely questions, the likely objections, the way Daniel's attorney would frame their narrative. She had told me to dress simply and speak only when spoken to, and to never, under any circumstances, react visibly in the courtroom to anything Daniel or his attorney said. Judges notice everything, she told me. They notice who looks at the clock. They notice who flinches. They notice who stays steady. I wore a dark gray blazer and flat shoes. I left the house early, drove in silence, and sat in the courthouse parking lot for 10 minutes before going in. The building was old Cook County stone, solid and impersonal. I took the stairs. Daniel was already in the corridor when I arrived, standing with his attorney, a man named Gerald Crane, expensive suit, aggressive posture. Patricia was not present. She had been advised by Crane not to attend. Daniel looked at me when I came in. I looked back, and then I sat down beside Barbara and opened the folder on my lap. The hearing was not a trial. It was a motion hearing, specifically on our motion to void the property transfer. But the judge had requested live testimony from Daniel on the question of the transmutation agreement. He was, in effect, going to have to explain under oath why the document he had signed 10 years ago shouldn't be enforced. His attorney had prepared an argument that Daniel had signed the document without fully understanding its legal implications, that Claire had guided him through the signing in a way that constituted misrepresentation, and that the agreement was therefore unenforceable. The argument, as Barbara had noted, had a central problem. It required Daniel to testify that he was a person who signed legal documents without reading or understanding them, a position that would simultaneously undermine his credibility on every other matter before the court. Daniel took the stand. His attorney walked him through the prepared narrative carefully. Daniel spoke about the estate planning conversation, about how he had trusted his wife to handle the paperwork, about how he had been distracted and had not understood what he was signing. He was calm, practiced. He had clearly rehearsed. Then Barbara stood up. "Mr. Merritt," she said, "you work in commercial real estate development, is that correct?" "Yes." "And in that professional capacity, you regularly review and execute legal contracts?" "Yes." "Would you characterize yourself as someone unfamiliar with legal documents?" A pause. "No, but—" "Thank you. Now, on the date you signed the transmutation agreement, you were present in the office of a licensed real estate attorney?" "Yes." "The document was notarized in your presence?" "Yes." "The notarization requires that you affirmed you were signing voluntarily and that you understood the nature of the document. Is that correct?" Another pause, longer this time. "Yes." "So your testimony today is that you, a commercial real estate professional who regularly reviews contracts, signed a legal document in an attorney's office in front of a notary, affirmed that you understood it, and did not, in fact, understand it." Gerald Crane objected. The judge sustained part of it but allowed Barbara to rephrase. She did. She asked the same essential question in 4 different ways over the next 20 minutes, each time coming back to the same immovable wall. Daniel's professional background, the circumstances of the signing, and the logical impossibility of his claimed ignorance. By the end of his testimony, Daniel's voice had changed. He was still speaking, but the precision had gone out of it. He was elaborating, qualifying, circling back. He was doing what people do when they are trying to reconcile a story with facts that don't support it. I watched him. I kept my face neutral. I breathed steadily. The next significant development was the financial disclosure, which discovery had compelled Daniel to produce in full. Barbara had cross-referenced it against our joint tax returns from the previous 7 years. The result was instructive. There were transfers from joint accounts in the 18 months preceding the divorce filing. Incremental, nothing dramatic enough to trigger alarm individually, but cumulatively amounting to approximately $47,000 moved into an account in Daniel's name alone. Barbara presented this to the judge not as an allegation, but as a documented discrepancy in need of explanation. Daniel's attorney objected that this was beyond the scope of the hearing. The judge noted it and said it would be relevant in the broader divorce proceedings. And then came the piece I had not anticipated. A small, perfectly timed gift from the opposition's own carelessness. Gerald Crane, in his closing argument on Daniel's behalf, stated that the house had been transferred to Patricia in good faith as part of routine estate planning. Barbara stood up. Your Honor, if this transfer was routine estate planning rather than a response to anticipated litigation, the respondent should have no difficulty producing the documentation of that estate planning. The prior drafts, the attorney consultations, the communications predating the marital difficulties. Crane said they would produce it. The judge set a deadline. They never produced it because it didn't exist. I sat in that courtroom, in my gray blazer with my folder on my lap, and I felt something settle into place inside me with the quiet finality of a door closing. Not triumph, not yet, but the cold, clear recognition that the story Daniel and Patricia had tried to write was coming apart at the seams. I did not smile, but on the inside, very briefly, I did. The judge's ruling came 5 weeks after the hearing, in a written order delivered to Barbara's office on a Tuesday in March. She called me immediately. Claire, she said, and her tone told me before the words did. The court found, based on the evidence presented, that the transfer of the Elmwood Drive property to Patricia Merritt had been made in anticipation of divorce proceedings, constituted a fraudulent conveyance under Illinois law, and was therefore void. The property reverted to its status as a marital asset, subject to equitable distribution in the divorce. The court further found that the transmutation agreement was valid and enforceable. The judge's written opinion, I read it 4 times, was precise and, in places, pointed. He noted that Daniel's testimony regarding his claimed ignorance of the agreement's content was inconsistent with his demonstrated professional experience and the circumstances of the document's execution. In the language of judicial opinions, this was as close to calling someone's story implausible as a judge will typically come in print. The ruling on financial disclosure ordered Daniel to account fully for the $47,000 in transfers, which would be factored into the overall marital estate division. What did the final divorce settlement look like? Barbara negotiated it over the following 8 weeks, backed by the ruling. The house was to be sold. Daniel had no interest in buying out my share, and I had no interest in remaining in it under those circumstances. From the sale proceeds, I was to receive 60%, reflective of my documented financial contributions, my labor on the property, and the court's assessment of the equities. Based on the listing price we ultimately accepted, my share came to approximately $342,000. I received my portion of the marital investment accounts, calculated after accounting for the $47,000 in unilateral transfers, for which Daniel was required to compensate me dollar for dollar. I received no alimony and did not ask for it. I had no interest in ongoing financial entanglement with Daniel Merritt. Patricia received nothing. The house had reverted from her name. The court had found her to be a participant in a fraudulent scheme. And while she faced no criminal charges, the transfer, though legally void, had not crossed into criminal fraud under Illinois law. Her ownership claim was extinguished entirely. She had received no benefit. She had incurred legal fees. She had been named in a court order that described a property transfer made in bad faith. For a woman who cared very much about appearances, who wore her good wool jacket to events she considered important and spoke carefully and smiled while calculating, this was a particular kind of defeat. Daniel called me once after the ruling. I didn't pick up. Barbara advised me not to, and in any case, I had nothing to say to him that a legal document hadn't already said more precisely. I sold my interest in the house through the process, moved my personal belongings into a rental apartment in a neighborhood I had always liked but never lived in, and sat in my new kitchen on the first morning with a cup of coffee and the particular quiet of a woman who has come through something. Was it hard? Yes. Was it long? Yes. Had it cost me? In legal fees, in sleepless weeks, in the specific grief of watching a marriage dissolve in the worst possible way, more than I had anticipated? Yes, but I walked away with my dignity, my financial stability, my son, and the knowledge that I had not been made into what Daniel had planned for me, a woman left with nothing. He had told me I would have nothing. He had been wrong about that. As it turned out, he had been wrong about quite a lot. I rented an apartment in Lincoln Square on the north side of Chicago, on the third floor of a building with tall windows and a view of the street below. It was smaller than the house on Elmwood Drive. It was entirely mine. The first thing I did was buy a plant for the windowsill. Not lavender. I had planted enough lavender in someone else's garden. I bought a rosemary plant and put it in the window where it got good afternoon light and watched it do well. I went back to work. Diane had held my position without question, and I returned to it with an attention and steadiness I hadn't felt in years. Within 6 months, I had been offered a senior position I had been passed over for twice in the preceding decade. I accepted it. Marcus came to visit in July. He helped me hang pictures, a set of framed prints I'd always kept in storage, because Daniel had found them too busy for the walls of the house. Marcus stood back and looked at them and said, "That's better," with the quiet authority of someone who has good taste and doesn't announce it. We walked along the lakefront one evening. At one point, he said without preamble, "I'm glad you didn't just take whatever they offered." "So am I said. "He thought you would," Marcus said. "I think he thought you'd be so scared you'd just accept it." "He didn't know me as well as he thought," I said. Marcus looked at the lake. No, he really didn't. What became of Daniel and Patricia? Daniel had moved back into Patricia's house in Oak Park after the ruling. 45 years old, living with his mother. The relationship he'd apparently been conducting before the divorce had not survived the circumstances. His professional reputation had taken a quiet but real hit. A court record describing your property transfer as fraudulent conveyance circulates in commercial real estate, and one of his longtime business partners had quietly distanced himself. Patricia had spent significant legal fees on a property she never received, been named in a court order and in her church community, where she had told people things were settled and secure. The subsequent reality had been quietly humiliating. They had planned to strip me of everything, and they had acted on that belief with confidence. What they hadn't accounted for was the one variable they hadn't bothered to investigate, what I had been quietly building by myself across the preceding decade. In my apartment in Lincoln Square, in the mornings before work, I made coffee and stood at the window and looked at the rosemary plant and felt the specific satisfaction of a life that belongs entirely to you. There was still grief for the marriage I had wanted it to be, for the years that couldn't be recovered. Grief doesn't resolve itself on a schedule, but underneath it was something solid, a floor that held. I had built it myself, and no one could take it from me. 10 years before Daniel told me I'd have nothing, I made a quiet choice, not out of fear, but out of clarity. I want you to take this away. Protect yourself before you need to. Read what you sign. Document what you build. Trust carefully and verify quietly. I didn't win because I was lucky. I won because I was prepared. What would you have done in my place? Would you have taken the settlement? Would you have trusted that the law would protect you without doing the work yourself? Leave your answer in the comments. And if this story moved you, subscribe. Thank you for listening.